Well, I'll tell you what, you're going to end up in the lockup in another 30 seconds. You are not going to stand there and yell at me. Who do you think you are? I got to tell you, top 3 most disrespectful that I've had in here in 32 years.
A man walked into a Michigan courtroom convinced the system was rigged against him. What happened next made a sitting judge say something he claimed he hadn't said in 32 years on the bench. Before this hearing ended, that judge would threaten to have the defendant locked up on the spot. And by the time the gavel came down, the real question wasn't who was lying about a broken transmission. It was whether the auction house that sold the vehicle had quietly rewritten the rules to protect itself. Stick with this one because the twist doesn't come until the very end. This case started with a car. A woman named Avery Thomas paid roughly $4,200 for a used vehicle at a public auction. Within 24 hours, the transmission failed completely. The car became undrivable. She lost transportation to work and to school.
Now, what you said is you purchased a vehicle from defendant in an auction for $42,0810. You said the defendant lied to something pre-existing transmission.
Failed to share pre-existing
transmission issues. Within less than 24 hours, the transmission failed and the vehicle became undrivable.
On paper, this looked like a simple small claims dispute over a defective vehicle. In practice, it became something far more revealing about how power operates inside institutions that are supposed to be neutral. The seller was a man named Stephen Pierce, who worked for the same auction house that facilitated the sale. That detail matters because it meant the person accused of hiding a mechanical defect had a working relationship with the very institution responsible for disclosing that defect to buyers. In consumer law, this is called a conflict of interest, a situation where someone's personal or professional relationships compromise their ability to act fairly toward another party. The auction house used a color-coded disclosure system. A green light meant the vehicle had been inspected and had no known mechanical issues. A red light meant the seller was disclosing a possible problem with the engine or transmission. That distinction is not a technicality. It's the entire foundation of informed consent in a sale. A buyer relies on that light to know what risk they're accepting. Pierce's position was that he never told anyone the transmission had a problem. He said the vehicle was sold red light for other reasons entirely. But Thomas testified that when she and her daughter arrived at the auction house, they asked an employee to explain the light system.
So I bought a car from a dealership at an auction, and the car, after a couple days, was messed up. So I talked to my wife, and I told her I don't feel comfortable. I could easily put it on Facebook and bet somebody in a parking lot and letting somebody get it like that. So I told her I would take it to an auction house. When I stepped in the auction house, me and my daughter, we asked the lady at the counter.
Who was it? Is she here?
I brought her last time. She's...
No. The lady at the counter. Who was that? What was her name?
I don't know if it's her or not. I don't think so.
Kim, she's on here.
Okay, go ahead.
I asked her, I said, could you tell me the difference between the lights? Which, by the way, don't make a difference because I've read 11 different reviews in the past 6 months on this guy's site that are 1 star from a green car that quit the very...
I don't want you to go into that right now. I just want to explain the light situation.
I'm just saying, sir, it doesn't mean much if they're buying green cars that are quitting. Sir, the difference is a red.
Just tell me what you were told.
So the lady told me a green car is something that their mechanic takes out for a test drive and declares that there's no mechanical issues. And then the yellow car, I forget what she said was for, and then she goes on the red car and she tells me a red car could have engine problems, could have transmission problems, and me and my daughter both at the same time go, yes, it's got something wrong with the transmission. She goes, oh, okay. And then I asked her if there's anything she needed me to sign. She handed me a piece of paper, told me all I needed to do was sign at the bottom. And then the lady even said that she was the lady.
According to her account, the moment the employee mentioned that a red light could indicate engine or transmission trouble, both women said, almost simultaneously, that the vehicle had exactly that kind of issue. If true, that statement would mean the seller's side had actual notice of the defect before the sale closed.
From him,
Her dad.
he was a police officer, and this wasn't going to go my way.
Her dad.
Yes. Then I called up and talked to, I think, maybe him.
Mr. Stone.
And I told him that I talked to a lady in your guys' lobby who had told me what the difference between the 3 red lights were, and then we told her that it would be a red light because we told her it had transmission. She marked it as a red light. Then he gave me an excuse that, well, some cars that come across my board are red light, but they work. And I asked him what was that excuse, and he says, well, when a creditor takes a car from somebody, all the cars run as a red light. And in my head, I'm thinking, okay, but a creditor takes a car from somebody, they don't want to take a chance at having it on the road and then them selling it as a green light and it has a problem, so they mark them all as red. Because when it sells, they chase the person they took
That's
it
the
from.
legal hinge the entire case swings on.
And I highlighted this after he did not sign it with the highlighted. I just want to say that for the record. I didn't.
Okay, hand that up.
I only highlighted so that way when I called him, I could quickly refer to it.
Okay.
That is a consignment form for a public seller. It's basically stating that if there are known transmission issues, it must be announced.
If the vehicle is properly functioning transmission unless otherwise listed above in announced conditions. There's nothing else announced conditions. All it says is extra key in office.
That is because when I talked to the lady at the desk, she told me that she was the lady who auctions the cars off. She's there at every auction and that she would remember. And I asked her if there was anything I needed to sign. The whole reason I found out it was a red car is because I asked her, tell me the difference. And when I told her, me and my daughter told her, it's transmission issues, which she heard. She says, okay, we got to mark it as a red car then. I said, is there anything else I need to sign? She said, it's just at the bottom right here.
Here's a number that should stop you within one day. The car this family paid over $4,000 for was completely unusable. Not a rattle, not a warning light. Full transmission failure in less than 24 hours. Enter the judge, a man who identified himself as having practiced law for over 40 years and served on the bench for more than 3 decades.
Let's get something straight. You're not walking in here like some grump and going to start talking to me like that. Let's get it straight right now. It's not happening. You act like I'm on their side. I'm not on anybody's side. I'm trying to find out what happened. I'm trying to make sure that I find the truth. Give me more credit. I've been a lawyer for 42 years. I've been a judge for 32.
From the moment the hearing began, he made clear he wasn't going to let procedure get buried under emotion. He walked both parties through their rights: the right to remove the case to a higher civil division, the right to hire an attorney, the right to a jury trial.
And I think everybody waived their rights last time. In other words, I covered everything with the 2 parties, with Avery Thomas and Stephen Pierce, about you waived your right to have the case removed, you waived your right to a trial by jury, you waived your right to hire a lawyer. Correct, Mr. Pierce?
Yeah.
Correct?
Specifically me when you said that.
Well, if you're in the small claims division, I thought I went through this. Maybe I didn't.
No, it's okay. I don't even go into it.
No, I want to. I want to. You don't have to. She sued you in the small claims division. You don't have to go to small claims. If you want, you can tell me, Judge, I want to remove the case to the general civil division. You can hire a lawyer. You can appeal my decision if you don't want it. You can demand a trial by jury. If you take the case to the general civil division. If you stay here, proceeding becomes much more relaxed. You can't appeal my decision, though. You can't hire a lawyer, and you can't have a trial by jury. Do you understand that? I can't hear you.
Yes.
Do you understand that?
Yes.
Do you waive those rights and wish to proceed here, Mr. Pierce?
No.
You don't waive those rights?
No.
Pierce initially waived those rights, agreeing to proceed informally. Then, mid-hearing, he reversed course and said he no longer wanted to waive them, even though the witnesses were already present and the informal proceeding was already underway. That inconsistency became the first crack in his credibility. But the real confrontation was still ahead. As the hearing progressed, Pierce grew increasingly agitated. He raised his voice. He pointed his finger toward one of the witnesses, closing the distance in a way the judge considered threatening.
The whole thing stacked against me. How are you going to have the same people that are trying to defend their stuff?
You get your
against the
head. Get your finger right by Ms. Howard's face. That's too close. We don't do that in. You have to trust me.
The judge stopped the proceeding cold. He told Pierce he was, in his words, among the most disrespectful people he'd encountered in 32 years on the bench.
2 weeks ago, did you tell them that, and I'm talking about the auction.
Do you remember when my daughter was standing right next to me and said that she walked into the auction house? When we sat to this, I don't even think this is a lady. And we said, hey, could you tell us the difference between the 3 lights? And they said, green light is this, yellow light is that, and red light, it could have engine or transmission problems. I said, well, it has something wrong with the transmission. Like, we got to put it as a red light. You didn't listen to my daughter as a
Sir, you got to calm down. What yell?
John, I'll tell you what. You're going to have a lot bigger problems if you don't show.
I don't care about it.
Well, I'll tell you what. You're going to end up in the lockup in another 30 seconds. You are not going to stand there and yell at me. Who do you think you are? Who do
He
you...
warned Pierce that continuing to escalate would end with him removed and held in contempt, a legal term for willfully disobeying or disrespecting the authority of a court, is punishable by fines or even jail time. This wasn't posturing. A judge has the direct authority to have someone taken into custody for contempt committed in open court. For a moment, it looked like this hearing might end not with a verdict, but with handcuffs. Think about the last time you watched someone in a position of power get challenged, and instead of engaging honestly, they doubled down and got louder. That's not just a courtroom pattern.
I mean, you are acting so childish right now. I can't even imagine. You came up here with piss and vigor from the very time that I called your case.
I shouldn't even be here right now.
Really? Okay. I'm glad you feel so confident about it.
That's a break room, a manager's office, a customer service call. Power under pressure reveals character. This case is no different. The judge called a recess.
I'm taking a 5-minute recess. I'd suggest you go splash some cold water on your face. And do not raise your voice with me again. Do we understand one another? Go splash some water on your face. Who do you
When the hearing
think?
resumed, he told Pierce plainly to calm down or the proceeding would not continue. Pierce agreed, but the tension didn't disappear. It just changed shape. What happened next is the moment this case stopped being about a broken transmission and started being about institutional self-protection. An auction house employee, and later a manager, took the stand. Their accounts conflicted with each other in real time.
So I had called Mr. Pierce, and I had said to him that the customer had an issue with transmission, and he said that he knew that. That's why he sold it through us. Otherwise, he could have just done it himself, which I would like to think that if he did sell it on the marketplace himself, he would tell that person well. But it was more or less like he was put the burden on us. So typically when there's an issue with a vehicle like this, we do call the seller and see if they can provide some kind of assistance to help with the buyer in this case. And he was not willing to do so.
One employee first said Pierce wanted to sell the car listed as green light, meaning no known issues. And then, seconds later, said he wanted it listed red light because he wanted to sell it, as is. Those two statements cannot both be true.
So he had brought in a vehicle to sell. I had asked him if he wanted to sell the vehicle red light, green light. Green light means that the vehicle is in working order. Trans and engine are good. Red light being sold as is. He said he wanted to sell the vehicle green light, that the vehicle was in working order, that there was no mechanical issues, there was no trans issues, and he wanted close to $6,000.
Okay. And ultimately, though, on the agreement, he checked the red light box, correct? Or somebody did?
I did, because he wanted to sell it red light.
I thought you initially said he wanted to sell it green light.
Well, correct. And then he said he wanted to sell it as is.
All right, so what caused you to check? That's your printing, if you will, on the vehicle description, color, VIN number, sale date, and title number, correct?
Correct.
What caused you then to check the red light box as opposed to the green light box?
Because he said he wanted to sell it as is.
Okay. But he'd already told you that he had some transmission problems, correct?
If Pierce wanted a clean green light listing, and the paperwork ended up red light instead, someone made that change. And the reason why matters enormously. Then came the paperwork itself. The consignment agreement Pierce signed stated the vehicle had a properly functioning transmission unless an issue was specifically listed under announced conditions. Under that section, the only thing written down was an extra key and a note about the office, nothing about a transmission problem. If Thomas's account was accurate, that the auction employee was told directly the car had transmission trouble. That information should have appeared in writing. It didn't.
I'm just telling you, if you're going to defend this on the basis that we didn't know there was an engine problem, and Mr. Pierce signs this, and you're going to highlight that portion that you've handed up, and I'll read it into the record, that the vehicle is properly functioning transmission unless otherwise listed above in announced conditions. I'm going to trust that when she signed this, that she crossed that out or somebody crossed that out, because at that point you guys knew that there was a bad transmission.
Yes.
You can't just hide behind lawyer legalese here either and start with all these fancy words. You're going to indemnify us and hold us harmless. Well, that's all nice. But I don't care what's in writing if somebody's perpetrating fraud. And I'm not saying you are. I'm not saying you are. I'm just going to point out to you and to this young lady that if her language that she signed is the same as his, you can't come in here and say he knew, and this is in paragraph 4, and, or whatever it is, paragraph 5, that the vehicle is properly functioning transmission unless otherwise listed above in announced
This
conditions.
is where the legal issue crystallizes. In consumer sales law, failing to disclose a known defect after being made aware of it can constitute a form of fraud, not because a form was filled out incorrectly, but because a party accepted money while withholding known, material information from the buyer. Here's the twist nobody in that courtroom saw coming. Just when it seemed like Pierce would be painted purely as the villain, he made an admission that complicated his own defense.
I'm not happy. I gotta tell you, top 3 most disrespectful that I've had in here in 32 years. Who do you think you are?
I'm not trying to be disrespectful.
Well, I gotta tell you, you must do it naturally then. You're like a know-it-all. Give me that back. I'll read it to you. Announced conditions of the transition. Transition.
Yep.
So that she disclosed that. You didn't. All this says under announced conditions is extra key in office. And you already slipped up once or twice, at least twice. And I'm just trying to get to the bottom of this, even though you've been belligerent. You already announced twice that you weren't going to go on Facebook. You thought you could have gone on Facebook and got what you paid for it. What does that tell me? So yeah,
He told the court that instead of using the auction house, he could have simply sold the car privately on a marketplace like Facebook and let an unsuspecting buyer take the risk without ever knowing about the transmission issue.
Problems like what?
Because I could have took it and I could have sold it on Facebook and got all my money back.
How can you say that?
Because that's what people do. But
Well, one crook doesn't justify another.
I didn't crook anybody. I walked into the auction house and me and my daughter asked the lady to go through the 3 lights. When she said red light was either for an engine or transmission problems, we said it has transmission problems. The lady said, okay, I'm going to mark it as a red light. And now I'm sitting here getting told that I'm trying to crook people. And you don't think this is one-sided?
He said this though it excused his conduct at the auction. It did the opposite. He had, in his own words, revealed that he understood exactly how serious the defect was and that avoiding disclosure to a private buyer was something he had actively considered. The judge caught it immediately. You can't claim ignorance about a problem in one sentence and describe strategies to hide that same problem in the next.
What I'm saying is you're telling me that you got essentially, that there was a fraud perpetrated on you when you bought it. And now you're saying you could have sold it on...
I bought the...
Stop. And now you're saying you could have sold it on Facebook and gotten all your money back, which means you would have had to tell people there was no problem with the vehicle. So you're not exactly making yourself look good.
So here's a question worth sitting with. If someone admits they could have deceived one buyer, does that make it more or less believable that they deceived another? The court didn't fully resolve that question. And honestly, neither will the comments section, because reasonable people land in different places here. In the end, the judge ruled against Pierce, ordering him to pay the difference between what Thomas paid for the vehicle and what she ultimately recovered reselling it, plus court costs, a total judgment of just under $3,000.
This young lady here, this Kimberly of Mescla, seems very, very, very credible to me. On the new consignment agreement that this young lady, Ms. Thomas, signed, it clearly spells out transition. I don't believe that you ever told her, and I know you're going to disagree. I'm just telling you why I'm holding like I'm holding. I don't believe you ever told her that you had a transition. I believe from her testimony for sure that she would have told you to note that on the seller's consignment agreement, which is why I wanted to see Ms. Thomas. I don't know why you're blaming everybody else, but that's neither here nor there. The plaintiff asked for $6,000. The plaintiff paid $42,0810. $1690 was the amount that she got. So there was a differential of $25,1810 plus the $250 for $2768.10. She is entitled to her court costs. So according to my total, it's $2,928.60.
Pierce was found liable for failing to disclose a known defect, but he was never charged criminally. No fraud statute was invoked. No referral was made to any regulatory body overseeing the auction house's disclosure practices. The institution itself, the one whose employees gave contradictory testimony under oath, walked away with no consequences at all. Justice was served for Avery Thomas. Accountability for the system that let this happen never arrived. The lesson here isn't really about cars or auctions. It's about what happens when the people responsible for disclosure also have the power to control the paperwork. Systems built to protect consumers only work when the humans inside them choose honesty over convenience. And when nobody does, the burden of proving fraud falls entirely on the person with the least power in the room.
There are days. I'm not going to argue with you, sir. I'm so convinced I'm right on this. That's it. That's the judgment amount. You need to figure out how you're going to pay them. How are you going to pay them?
I don't know, because I was in a crash 15 months ago. I've lost a 2019 Ford Ranger. I've lost a 2024 Harley Davidson. And I got a truck out there with a blown window, doesn't have AC in it. And I tried to do the right thing here, and I'm getting screwed over.
Do you work?
I can't work right now, sir. I'm physically unable to work. I broke 5 bones below my waist. My wife had rolled me outside a pin of buckets. The same company that you're trying to defend has 10 different 1 stars for green lights. Green lights, if they quit within 24 hours, they're supposed to give their money back. They got 10 people complaining they ain't got a dime from them for green lights. They quit the next day.
I am not defending anybody. I'm sorry you disagree. I really am. I'm sorry you're going through that. I really am. Maybe
if you learned something from this case, tell us in the comments which courtroom clash or legal case you want broken down next. Subscribe and share this video, because an informed public is the best defense against exactly this kind of quiet, paperwork deep injustice.